So dapat, dininig muna po ng Korte Suprema, meron ba talagang potential violation of the right to life? Meaning, na yung kalagayan ba ng dating Pangulo, life-threatening ho ba? So yun po, wala pong hearing.
May nabanggit kayo kaninang order o notice of order na nagbuhat sa Korte Suprema na ipinalabas ng Korte Suprema noong Nobyembre 18, 2011. Pinakikita ko po sa inyo itong notice of resolution na kanina po ay minarkahang exhibit non-Paul U. Ito po bang tinutukoy ninyo? Na order na nanggaling sa
Opo.
Matas na Human. Mangyari po bang basahin na ninyo dito sa page 2 yung paragraph C na nauukol sa urgent motion for reconsideration?
Opo.
Para po, ito po ay bagay dun sa katatanungan kanina ng Ginoong Pangulo.
It says, as one of the dispositions of this resolution, November 18, deny the consolidated urgent motion for reconsideration and or to lift temporary restraining order dated November 16, 2011, filed with the Office of the Solicitor General for Public Respondents Laila de Lima in her capacity as Secretary of Justice, Ricardo David Jr. in his capacity as Commissioner of the Bureau of Immigration, and Ricardo V. Paras III in his capacity as Chief State Counsel.
Thank you. Nabanggit ninyo na mayroong dissenting opinion si Justice Sereno ukol dito sa panibagong order na ito na bumaba na nanggaling sa Korte Suprema noong Nobyembre 18, 2011. Dito po, kalakip nitong exhibit ay exhibit non-Paul Judas 1. Ito po ba yung tinutukoy ninyong dissenting opinion ni Justice Sereno?
Opo, dito po sa November 18. So, aside from yung dissenting opinion niya po sa November 15, which was the TRO, meron ho uling dissenting opinion si Justice Sereno dito sa November 18, 2011. Tungkol nga po sa pag-deny ng TRO. Tsaka meron po siyang mga dinisclose dito tungkol dun sa mga botohan na naganap sa Korte Suprema dun sa usapin ng TRO. Yan ba kung ano ang tunay na nature ng TRO, kung conditional ba o hindi, at yung pangalawang tanong, yun ba ay nasuspend ba yung efficacy or effectivity ng TRO dahil nga hindi nasunod yung kondisyon, isa sa mga kondisyon ng TRO. Nakalagay po dyan yung mga informasyon.
Ano ba yung kondisyon na hindi natupad?
Ang tinutukoy po dito ay yung tungkol sa condition number 2. Yung sa TRO po, yung condition number 2 is about the appointment of a legal representative or representatives of both petitioners, common to both petitioners, with authority to receive legal summons and other processes of the court. More or less po, ganun yung tono ng...
But the other conditions were complied.
Yung first condition po, it would appear it was complied with, and this was also disclosed in a later dissenting opinion of Justice Sereno. Mga banda ho atang alas 6 ng November 15, the day that the TRO was issued, dun ho nakapag-bayad o nakapag-submit nung 2 million bond. Pero yung number 2, although meron pong sinubmit yung abogado, if I'm not mistaken, Attorney Topacio, na something which purports to be the special power of attorney, defective ho. Sabi, dahil imbis na ang sasabihin is with authority to receive legal summons ang nakasabi po doon sa special power of attorney ni sinabmit ni Attorney Topacio ay to produce legal summons. Kaya it was disclosed subsequently, especially in the dissenting opinions of Justice Sereno and Justice Carpio, na walang compliance. And in fact, sabi po sa dissenting opinion ni Justice Sereno, by a vote of 7-6, ang ruling ng korte is there was no compliance with condition number 2 as of November 15 and even November 16 or succeeding days.
Babalikan ko po ang Administrator ng Korte Suprema na nabanggit niyo kanina, si Ginoong Midas Marquez. Noong Nobyembre 18, noong taong 2011, meron po ba kayong natatandaang anumang nakita sa telebisyon ukol sa
Kailan po yun? Ano po date?
November 18, meron po ba?
Opo. May press con na naman po si Ginoong Marquez noong November 18. I think as an offshoot noong pag-issue nga po nitong November 18, 2011.
Ano po ang mga sinabi ni Mr. Marquez doon sa press conference na sa palagay ko ang tinutukoy nyo, nakita nyo sa television?
Hindi ko na po natatandaan lahat. Ang natatandaan ko lang po na medyo importante hong masabi, and this can be confirmed, ay pinaliwanag niya na effective na daw po talaga yung TRO. Wala siyang sinasabi na nagkaroon ng botohan na there was non-compliance with that condition, and yung unang botohan ho ng Supreme Court, again based on the disclosures of Justices Sereno and Carpio in their dissenting opinions, ay ang by 7-6, ang ano nila is that hindi na nila kailangan sabihin kung suspended ba talaga yung TRO kasi clear naman daw po o it's common sense, quoting one of the justices, na it's common sense that it's understood that because the TRO is subject to certain conditions, pending the compliance with those conditions, it cannot be considered as already effective. Yung parang ang naging consensus nila as disclosed by Justice Sereno, dahil malinaw naman po daw yon, that's fundamental na conditional, so hindi na nila kailangang sabihin na it was deemed suspended. That was the first voting. Mahaba hong istorya, meron hong other.
Okay.
If Your Honor, please,
I'll ask.
with the kind indulgence of the Honor.
I'll ask the questions. I'll
Last
ask questions.
question,
Yes, I will do that.
No,
I'll ask
because with due respect, Your Honor, it seems that the testimony of the witness now is beyond the purpose. This is practically amending, criticizing the decision of the Honorable Court. It has nothing to do with the alleged impeachment complaint against Chief Justice Corona, Your Honor. As I will be may I be permitted, Your Honor, to go into the impeachment complaint, Your Honor. Respondent betrayed the public trust through his partiality in granting a temporary restraining order in favor of former. Now, this alone, the charge is that there was that the guilty party, meaning Chief Justice Corona, issued the restraining order, Your Honor, in violation allegedly of any provision of law or culpable violation of the Constitution, Your Honor. But thus far, nothing had surfaced to this effect. What is being discussed with due respect to the witness, Your Honor, are matters which are entirely irrelevant and impertinent. The Court can take judicial notice, Your Honor, of the nature of the proceedings before the Supreme Court. It is a collegiate court. There can be no restraining order on any decision that can come out without the majority participating therein, whether it is an en banc decision or merely a decision in division, Your Honor. We had been very tolerant in this matter, Your Honor, because we were quite at a loss as to the real purpose of the introduction of the Honorable Secretary in connection with these matters, Your Honor.
The understanding of the presiding officer is that the Secretary of Justice was introduced to narrate the history of the issuance of the TROs against her with respect to the enforcement of circular number 41
Yes, sir.
and the watch list orders. And there was a TRO issued against her that is within her knowledge, and that the dissenting opinion is a part of the record of the TRO.
Yeah.
Correct?
Yes, Your Honor, but with due respect to the... May I?
Yes.
This is an impeachment complaint, Your Honor, against Chief Justice Corona. Under paragraph 7, he is being impeached because allegedly he masterminded the granting of a temporary restraining order. Up to this point, Your Honor, I see no testimony to that effect. What is being attacked now is the validity, the legality, or the infirmity of...
Anyway, we are intelligent enough to read the Article 7 and relate it to the testimony of the witness. So, counsel, have faith in the
I have more than...
the
I have
ability
more than...
of these elected senators to evaluate the evidence that are going to be presented here.
I'm only trying to exercise some sort of protection in favor of the client of the Chief Justice, Your Honor.
I understand where you're coming from, and we will be able to shift between what is knowledge and what is hearsay evidence.
It is not merely with the kind indulgence of
We
the
are not
Honorable...
reviewing the decision of the Supreme Court. We are just getting the narration of the witness with respect to her knowledge of what transpired with respect to the issuance of the TRO against her.
Yes, Your Honor, I fully agree with that. There may be some infirmity, there may be some irregularity, but our center point here is the alleged participation of the Honorable Justice Corona, who is being impeached, Your Honor. That's my point. That's my point of objection.
Let us wait for the finality of the direct examination of the distinguished Secretary of Justice.
Okay, thank you, Your Honor. I was a little bit reluctant because of the testimony is being adduced by the Honorable Secretary of Justice. I was once Secretary of Justice. I do not want to be placed in a position that she is now, Your Honor.
Well, she's the witness called by the prosecution, and let us hear her. We realize that from herself, it was not the respondent alone that issued the TRO, it was the Supreme Court and bank. So we know this. It's from the mouth of the Honorable Secretary of Justice. So proceed.
Thank you. Thank you then, Your Honor.
Thank you.
Sorry.